Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the appointment of fiduciaries as part of your estate plan. This is the second in a series of 9 articles about the 8 goals of a good estate plan. The previous article and podcast we did dealt with laying out what those 8 goals are. And the first goal is appointment of fiduciaries and distribution of assets. And I lumped those two things together because they kind of go hand in hand. A fiduciary is the person responsible for distributing your assets. But it's kind of such a big topic to talk about that we're, for the purpose of our podcast here, splitting it into 2. And today we're just going to talk about appointment of fiduciaries and who your fiduciaries are in a good estate plan. And next time we'll talk about considerations that you should think about when distributing your assets through an estate plan. So this is really goal number 1A, and it's appointment of fiduciaries, and that's what we're going to talk about today. So what is a fiduciary? A fiduciary is someone who has an ethical or legal responsibility to manage the affairs of another person. They're held to a high standard of care, a fiduciary duty that's higher than a regular standard of care that a loved one has for someone else, because of the trust that the person that named them as fiduciary is placing in them to handle their affairs. So they have to refrain from any self-dealing and really act with the utmost professionalism and care and really look out for the benefits of the person for whom they are the fiduciary. So when you create an estate plan, a good estate plan, you'll be appointing a whole bunch of different people to act for you in certain situations, and these are called fiduciaries. And not every estate plan has all of these, but we'll cover what they are and explain what documents create them and how they work. So the fiduciaries that you create in a good estate plan are the trustee of your trust, the executor of your estate, the financial agent that you name via your power of attorney, the healthcare agent that you name via your healthcare power of attorney, the guardian of your person should you become mentally incompetent, also named through your healthcare power of attorney, and the guardian for your minor children if you have any that's named in your will. So we'll dissect each one of these and look through each one and try to explain to you what each of these fiduciary responsibilities entails. So let's start with the trustee of your trust. When you have a revocable living trust, it's an entity that can own your property both during your lifetime and after you pass away. And the trust lays out how you want your property dealt with. And if you have a joint trust with your spouse, which we commonly do for married couples, you and your spouse will start off as the trustee, and you'll also start off as jointly beneficiaries. And as trustees, you're the person that has the responsibility to manage the assets in the trust according to the terms of the trust for the benefit of your beneficiaries. During your lifetime, and while you're still both mentally competent, you're both trustees and beneficiaries, so your only duty is to yourself. So you don't really even notice the difference between owning the assets in your individual name and owning them in the trust, because you don't. There's not really much of a fiduciary duty there because your only duty is to act for your own benefit. But things get more interesting once one of you becomes mentally incompetent or passes away. So let's kind of game this out and explain how this will work. So if you have a joint trust and you're both jointly trustees and one of you becomes mentally incompetent, whether it's through disease, old age, or injury, the mentally competent spouse remains a trustee, but the mentally incompetent person, once they're certified as mentally incompetent, is no longer a trustee of the trust. But they're still a beneficiary. So you've now got one trustee, the mentally competent spouse, and 2 beneficiaries, both spouses. So the mentally competent spouse now has a fiduciary duty to act with respect to the trust according to its terms for the benefit of both spouses. If that mentally competent spouse were to pass away, you'll have named successor trustees in your trust. And these are usually family members or loved ones, and they act in order. The first that's able and willing to act, and they take over the job of trustee when you and your spouse can no longer be trustee. So in this scenario, you've named some successor trustees, maybe they're family members, and your mentally competent spouse has passed away and you're mentally incompetent. So now you're the sole beneficiary of the trust, and the first successor trustee takes over and is responsible for managing the assets of the trust for the rest of your lifetime for your benefit according to the terms that you've laid out in the trust. Then when you pass away, when the second spouse passes away, the trustee is responsible for dividing those assets according to the terms that you've laid out in the trust to your heirs. Now, sometimes someone will pass away with a child, or a minor child, or a young adult child, maybe under the age of 30. And in the trust, you have the ability to lay out certain age limits on when those children can get access to those assets. So usually what we'll say is that when the first, when the second adult passes away, the second parent passes away, there's going to be a child single fund trust created that's just for the benefit of all the kids that are under the age of 21. So that'll be in effect until the last kid turns 21. And its only purpose is to basically pay for the care of the children that are under the age of 21 and get them to adulthood. And then once the last child turns 21, whatever's left in that children's single fund trust is going to be divided into separate trusts for each child that's surviving. And what parents will do is say that at 21, each of those kids can get it a third of the assets in the trust without trustee approval. At 25, they can get it 2/3, and at 30, they can get it the rest. And you can put whatever restrictions you want, but that's just the most common one. So then the successor trustee is going to be responsible for both managing the child's single fund trust until that expires when the last child reaches the age of 21, and then managing the assets in the child's separate trusts until the children reach the age where they can demand the last of those assets and have those paid out to them if they so choose. Until the children reach those age restrictions, let's say 21, 25, and 30 to get a third, 2/3, and the rest of their trust, the trustee has discretion to pay out as much or as little of the trust for the benefit of the children as the trustee feels would be in their benefit. So, for example, if your daughter comes to you or comes to your trustee at age 22 and says, I need the rest of my trust to pay for grad school. I know the trust says I can only demand a third of it at this point, but I need the whole thing to pay for grad school. I want to be a doctor. The trustee can say, well, that's a pretty good use of the trust fund, so we're gonna allow that and clear out the trust fund to pay for her grad school. But if your 22-year-old son comes to you and says, or comes to the trustee and says, I really want to attract some girls, I need a Lamborghini, give me the rest of my trust money, the trustee can say, no, you only have access to a third of your trust money. I have to pay that out to you, but I'm not giving you the second third until you reach age 25, and I'm not giving you the rest until you reach age 30 unless you give me a better reason to do that. So the trustee is really responsible for managing the assets of the trust after you pass away for your children or for your beneficiaries. Now, if you don't have children under the age of 30, or if you don't put age restrictions on it, what a lot of people do is just say it'll be distributed to person A, person B, and person C immediately upon my death. And if that's the case, then the trustee is the person responsible for doing that. And if you've successfully avoided probate, which is the whole purpose of the trust, then the trustee is also going to manage everything that's outside of the trust at the time of your death. All that will get swept into the trust at the time of your death. And then without a probate estate, your trustee will be able to immediately, and really without hiring an attorney, distribute the assets of the estate immediately upon your death through the trust mechanism. So that's what a trustee does, and that's really the most important fiduciary in the estate plan. The next one on the list is the executor of your estate. So the executor is the person that deals with your estate if for some reason it has to go through probate, or if you don't have a trust. This is the person you name in your will to manage the distribution of your assets when you pass away. Unlike a trustee, they're not going to have any powers over your assets if you become mentally incompetent. This is only when you pass away. And unlike a trustee of a trust, they're not going to be able to have any long-term control over these assets. They basically just go through a probate case and make sure that they're distributed to the right people according to the terms of your will. So if you have a trust and you have a pour-over will that's basically to cover if for some reason probate becomes necessary, then your trustee is going to handle everything that's actually in your trust. And if your estate goes through probate, your executor handles everything that actually has to go through the probate estate that's outside of the trust. And that's, again, only if probate is necessary. So a lot of people will name the trustee and the executor to be the same person so that there's no issue there, if for some reason probate becomes necessary despite their trust. And again, if there is no trust, even if there's no probate, the executor is the person responsible for dividing up your assets according to the terms of your will. So while we're on the topic of your will, let's talk about guardians for minor children. This is also something that you name in your will, and this is the person that has the basically that you've appointed to be the guardian of your minor children if you either become mentally incompetent and you're not able to be the guardian yourself, or both parents have passed away. And this is really important. This is one of the most important things that people want to do in an estate plan, is make sure that they've named the right people to raise their kids, because that's the most important thing they can do. And that's something that you do in a pour-over will. And you can name successors, so you can say the first of the following who's able to act is going to be the guardian. And the other nice thing about naming a guardian is that it avoids a guardianship contest when you pass away. The guardian won't have to have a battle in guardianship court over who's actually going to raise the kids when you pass away. And we see that a lot when you don't actually name a guardian. So next, let's talk about the financial power of attorney. And this is where you name a financial agent to act for you in all financial and legal affairs if you become mentally incompetent. So far we've talked about mostly what happens when you pass away. Now we're talking about what happens if you become mentally incompetent from old age, disease, or an accident, or for any other reason. And if that happens, if you have a financial power of attorney in place, you've already appointed someone that can pay your taxes, pay your bills, sell your house if they need to, maintain a lawsuit on your behalf, do everything in the financial and legal world that needs to be done to manage your affairs. And that's called your financial agent. That's appointed through a financial power of attorney, also called the power of attorney for property. Now this has a strange interplay with your trustee, because your trustee is still the person responsible for managing all of the assets in your trust. But your financial power of attorney has broader powers. They deal with everything that's outside of the trust and deal with all legal matters like filing your taxes, like maintaining a lawsuit that the trustee really can't do. So next we'll talk about your healthcare agent that you appoint through your healthcare power of attorney. Now in your healthcare power of attorney you appoint two fiduciaries. One is your healthcare agent that's going to make major healthcare decisions for you, and the other is the guardian of your person that makes major life decisions for you, like where you're going to live. The healthcare agent, pretty obvious. They're the person that if there's a risky surgery and the doctor needs someone to make a decision on whether to attempt that risky surgery to save your life, the healthcare agent is the person that makes that decision. They also, in the absence of a living will, are the person that makes the end-of-life decision if you're in an irreversible coma. So they're the person that decides, are we gonna terminate life support if the doctors think there's no chance of you coming out of this coma. Now, in a healthcare power of attorney, you can state your wishes as to what you'd like to happen in that situation. But unless you have a living will that orders the doctor to terminate life support without consulting your healthcare agent in that situation, your healthcare agent is still going to have the ultimate decision, the ultimate legal decision, despite what you state in your healthcare power of attorney. And usually your healthcare agent is the same person as the guardian of your person, also appointed through the healthcare power of attorney. And this is basically the person who decides whether you're going to be checked into an assisted living facility, where you're going to live, and makes your major non-financial life decisions for you. So your financial agent is the person that manages your accounts, files your taxes. The guardian of your person is the person that decides, basically where you're going to live and is responsible for you on a day-to-day caring basis. If you have both a healthcare agent and a guardian of your person named and a financial agent named, then if you become mentally incompetent, an expensive guardianship proceeding won't be necessary, because you've basically named both your financial guardian and your guardian of your person that would do everything that a guardian would do if named in a guardianship proceeding. And really, that's it. Let's review what we've talked about. We've talked about the trustee that you've named in your trust, the executor that you've named in your will, the guardian of minor children that you've named in your will, the financial agent that you name in your financial power of attorney, and the healthcare agent and your guardian that you name in your healthcare power of attorney. And those are the people, usually, again, family members or loved ones or friends, that you really trust to make the right decisions on your behalf if you're not able to do so. So next time we're going to talk about distribution of assets as part 2 of the first goal of a good estate plan. We've already written articles on all these topics, so if you're curious, you can go to learn-about-law.com and learn more about all of the 8 goals of a good estate plan, or any of the other areas of law that we practice, which is most of them. If you want to learn about business, you can go to seizeyourbusiness.com and check out our podcast and video blog for business owners. So hope this was helpful. Thanks so much for listening.